Lordship,
Yes.
if I may seek your indulgence in mentioning item number 8 of the hearing list.
Item number
8.
8. Yes.
That if this matter can be taken up after a week.
You are for the appellant?
Petitioner.
Appellant or respondent?
Appellant.
Appellant, okay.
My lord, I'm the respondent, and if we can have with us a fixed date
Next week, a fixed date.
on 20th of November.
20th of November.
Yes.
Is that okay? Learned counsel for the appellant, Mr. Such and Such praised for an adjournment. And in the meantime, the learned counsel, Mr. Such and Such for the respondent, has prayed for listing the matter on 20th November, which is not objected to by the learned counsel for the appellant. Stop accordingly list on 20/11/2025. Yes.
Highly obliged.
Follows with regard to part 2, item number 9.
9. Yes.
Even though I cannot call the respondent, counsel for the respondent, this item may come up on Thursday, if it please your lordship, for hearing.
Thursday.
Thursday, or next week.
Next week, I think, because I'm leaving on Friday and may be a bit difficult if I reserve it. No?
I mean, it can be fixed next week.
Okay. Learned counsel for the you are for the appellant.
Appellant.
Learned counsel for the appellant in the and who submits who makes a prayer for mentioning for listing next week. Stop the learned counsel. What about respondent?
They are absent today.
Okay, learned counsel for the respondent is not present. List next week. Yes.
Obliged.
If I may seek your lordship indulgence regarding part 2, item number 10, my lord.
Item
Number 10.
10. Okay.
With the consent of the other party, my lord.
Yes.
If the matter may be taken up on Thursday this week.
Thursday may be difficult. What about Wednesday?
My lord,
Tomorrow or
it's fine.
Wednesday?
Fine, my lord.
This matter on Wednesday. Give the date, okay? On the prayer of the learned counsels for the parties. Yes.
Highly obliged.
May I seek your lordship's indulgence in mentioning item number 13 of part 2, my lord. On behalf of the amicus, if this matter be fixed for the 29th, that is the Wednesday.
Item 13.
Yes, my lord.
Learned counsel for the. When do you want? 29th.
29th.
Okay. Learned counsel.
I'm
for
appearing
the,
on behalf of the amicus, my lord.
Okay, her learned counsel, such and such, mentioning on behalf of the amicus curiae in the present matter, who prays for listing the matter on the. What about the PP? 29th is okay. But we have already fixed one matter on 29th. So next week,
Okay.
next week, list the matter next week. Yes. Next week.
May I please, your lordship?
Yes.
With the consent of other side, I beg to mention item number 5, your lordship. I'm
Yes.
praying on behalf of Iqbal Hussain Laskar. He is on bereavement, your lordship. So I've taken the consent. Can it be fixed on 3rd of November?
Who's in bereavement?
Iqbal Hussain Laskar is the conducting counsel.
Hussein. His name is not there in the cost list.
No, cause this his name is there.
Item 5.
Item 5.
Learned counsel.
Part 1, your lordship.
Oh, part 1.
Yes.
Okay. Part 1, item 5. Learned counsel that makes a mention on behalf of the leading counsel, Mr. Iqbal Hussain, who is stated to be in bereavement, and accordingly prays for listing the matter
On 3rd of November.
on 3rd of November. Stop. Praise allowed. List on 3rd November 2025. Yes.
Obliged.
My lord, may I make a mention regarding item 5 of hearing list?
Yes.
This dispute is between siblings, so it may be referred to mediation, my lord, with the consent of the other side.
Mediation.
Mediation, my lord. There will be hope for settlement.
Okay, but that mediation for the nation, that drive is already over, I think.
I see. Then lok adalat, my lord. We have spoken
but,
to
but the mediation center is here, I
Yes,
think.
yes.
Yes.
In the High Court. Okay. Learned counsels for the appellant as well as the respondent have submitted that there are ingredients of settlement in the present appeal, and therefore praise that the matter may be referred for mediation. So, accordingly, on the prayer of the parties, the matter is referred for mediation. Before the Guwahati High Court Aizawl Bench Mediation Center. So, the coordinator. Who is the coordinator in the mediation center, or is it the registrar?
Registrar may be addressed, ma'am.
The registrar, Guwahati High Court Aizawl Bench, shall fix a date, or you appear before him. Okay, the parties shall appear before the registrar, Guwahati High Court Kohima Bench on when?
Aizawl Bench,
My
ma'am.
lord, Aizawl Bench.
Oh, sorry, Aizawl Bench next week. Just to
After-
fix a date. Just to fix a
Yes,
date.
my lord, next week.
On the 3rd of November 2025, and the registrar shall fix the date accordingly for the mediation process. Stop. List after completion of the mediation proceedings. Yes.
Duty obliged.
Much obliged.
For admission, item 1.
In this case, my lord, writ appeal is pending. My lord, on last occasion it was again takes on 4th of December. My lord. The
What is pending? Writ appeal.
writ appeal, my lord, and it was the order of writ petition is already stayed, my lord.
Okay.
Writ appeal 320 of 2023.
Writ appeal
320
320 of
2023.
2023.
Yes.
Learned Counsel.
I'm for respondent SK Medi.
Okay. Learned Counsel, Mr. S.K. Medi, appearing for the respondent, has submitted that a writ appeal has been filed against the against the order dated 15/11/2022 passed in WPC 119 of 2021, and the same has been registered as writ appeal 320/2023, wherein the order dated 15/11/2022 has been stayed by the division bench. Stop. Accordingly, he prays that this matter may be listed
On 5th of December.
after the disposal.
After 5th of December, my lord,
May be listed on 5th December 2025. Stop. Prayers allowed. Learned Counsel for the petitioner is such and such is present. List on 5th December 2025.
my lord.
Item 2.
Please, Your Lordship, by filing this revision petition, Your Lordship, we're challenging one order passed by the executing court. Everything boils down to the interpretation of the terms of settlement that was arrived at between the parties.
My lord, I'll be
Lok
filing.
Adalat Award.
Yes, Your Lordship.
Okay. So, on the previous occasion, there was a direction to translate the award.
Correct, Your Lordship. That has been done.
That has been done. Who's appearing? You are appearing for
Yes,
the respondent?
Yes, and I'll be filing affidavit in opposition during the course of the.
You have filed.
No, I will be filing
You will be filing.
during the course of the day. Yes,
When? Today?
today. Yes.
The parties, the learned counsels for the parties are present. So, by order dated 1/9/2025, this court had directed the registry to translate the Lok Adalat Award at page 14 of the petition. And accordingly, the same has been done and it's placed on record. Stop. The learned counsel, Mr. such and such, appearing for the sole respondent, submits that he will be filing his objections during the course of the day. Stop. Accordingly, list the matter when.
Can it be listed this week, Your Lordship? The reason being is that, my Lord, it only boils down to interpretation of one line of the Lok Adalat agreement. Out here, what happened was that there was a property dispute. So, as per the settlement, we were supposed to pay them a certain amount of money. And in the Lok Adalat terms of settlement, it was mentioned that efforts should be made to pay up the entire amount by 2010. Now, when they filed we tried paying the amount and they refused to accept it. And the period of 2010 expired. And now they're saying that since you have not paid, you have to give back the property to us. So, whether this 2010 timeline is mandatory or not, everything boils down to that interpretation only. Because out here, even in the translation, it says efforts should be made to pay up the entire amount during the year 2010. That's all. This is where we are stuck.
Efforts should be made is to pay up the entire amount during the, if they are unable to pay up the entire amount of such and such, so they will take back that. No, but even after 2010,
We can still pay, in our humble opinion. So during the entire execution proceedings, even in our written objections, we had submitted on affidavit saying that we are ready to pay, but they were not willing to accept. That was the only issue.
why are they not willing to accept?
My Lord,
They've-
in
I
our
think they've changed
version,
of-
they
change of
didn't try to make the payment.
We might,
They
we
are
tried.
alleging that they are trying to pay payment.
It's
but in our
very
version,
simple
it's not
actually. It's a very
like that.
simple matter actually.
Yes.
If they pay and you accept, then that's the end of the matter.
That's all, madam.
Then
Yes.
okay, we list it on Thursday. Thursday would be 27.
30.
No, sorry, 29. No, 30.
30.
30. Yeah, list. You list on 30. Yes.
Deeply obliged.
Item 3.
Lordship, in this matter, in the last court date, time was given to the government to appoint another counsel to this matter because the counsel who was previously handling the matter is on maternity leave. And so,
Otherwise, a counter affidavit is filed. Counter affidavit filed.
They had filed one previously, but
Yes. Learned counsel for the petition is present. Stop. Learned government advocate, Miss such and such. Yes. Have you filed? Has government filed the reply?
Your Lordship, the leading government advocate is on leave. At this moment, I don't know whether she filed or not.
Because I don't see anything in the records.
I believe she didn't file yet.
Learned government advocate such and such is present and submits that the government advocate who is entrusted with the with this matter, Mrs. Caroline K. Langwipui, is on maternity leave. When is she coming back? If she is going to take time, then you can take over. It's okay.
Yes, Your Lordship, I believe she took leave till 31st of this month.
Till 31st of this month. And that the said government advocate is on leave till the till 31/10/2025. Stop. Accordingly, list the matter after 2 weeks. List the matter after 2 weeks. In order to enable the state respondents to file their counter affidavit.
Item 4.
Affidavits not filed. affidavit of R2 is there. Affidavit of R2. 3 to 5.
Lordship, I am for respondent number 1, similar prayer.
Respondent 1 also 3 weeks.
And I'm from respondent number 6, similar prayer.
Respondent 6 also 3 weeks. Okay, learned counsel for the petitioner, Mr. Victor Relte is present. Stop. Learned government advocate Ms. Vani Siami has prayed for 3 weeks time to file the counter affidavit on behalf of respondents number 3 to 5. Stop. Similar prayer is made by the by the counsels appearing for respondent number 1 and 6. Learned AG, as additional AG, is appearing. Oh, as standing counsel.
NHIDCL.
Okay. Learned counsels and such appearing for the NHIDCL respondent number 2 has already filed the counter affidavit. Stop. Recording prayers allowed. List after 3 weeks.
Item 6.
May it please, Your Lordship. My Lord, as per office note dated 16/10/2025, notice upon respondent 1 and 2 has returned unserved with the remark insufficient address. And as far as respondent number 3 is concerned, the AD card has not yet returned.
My Lord, I have an instruction to appear on behalf of respondent number 1.
1.
Honor.
Only 1.
Only 1.
Then for R2, you take first steps.
With Your Lordship's permission, if I may be allowed to obtain the copy of the MAC appeal, the unserved MAC appeal, so for initiating fresh steps.
A copy of?
The appeal memo, which was previously sent, has come back.
Okay. You're appearing for the appellant.
I'm for the
isn't it?
appellant.
Learned counsel, Mr. Hassan is present for the appellant. Stop. Learned counsel, Ms.
Ruth
such appears for the respondent number 1. And are you going to file any objection?
Yes, my Lord, I'll be needing 2 weeks' time.
And has prayed for 2 weeks' time to file her objections. Stop. The notice on respondent number 2 has returned unserved with a note, inverted commas, RTS insufficient address, close inverted commas. Stop. The service report on respondent number 3 has not returned back. Stop. Accordingly, the counsel for the appellant shall take first steps for notice on the respondent number 2. Stop. And the registry from the registry, isn't it?
Yes, sir.
And the registry is directed to furnish a copy of
the unserved
copy
of the appeal memo.
To return the copy of the unserved appeal memo to the counsel for the appellant. Stop. List after 2 weeks.
May please, Your Lordship. My Lord, since the respondent number 2 is a resident of Aizawl, if I may be allowed to take steps by way of Dusty as well, if possible.
Before that, you say the learned counsel for the appellant is also permitted to take steps by Dusty mode on the respondent number 2 and thereafter file the affidavit of service. Yes.
Deeply obliged.
Item 7.
My Lord, paperwork has been received. The matter may be fixed for hearing.
The paper book received all parties.
Yes.
Okay. Learned counsel for the appellant as well as the learned PP submits that the paper book has been received. So the matter is ready for hearing. Accordingly, list the matter for hearing in usual course.
Yes.
In usual course.
Item 8.
Your Lordship, in this matter of notice
My pleasure, Lordship. My Lord, this IA is for condonation of delay in filing the impugned judgment and award dated 27/9/2024, passed by the learned MSCT, Aizawl District, in MSCT case number 3 of 2023, my Lord. My Lord, in this application, I have clearly indicated that there was no intention or willful negligence on the part of the applicant, my Lord, in filing the appeal belatedly, my Lord. There's a delay of 153 days, my Lord.
1 minute, okay.
My Lord.
Who is appearing for the respondents?
Your Lordship, for the respondent number 1.
For the claimant?
Claimant, yes.
Yes. How many days?
153, my Lord. 153 days.
Okay, let's see your causes.
My Lord. My Lord, the impugned judgment and order dated 27/9/2024, it was received by the empaneled lawyer on 30/10/24, my Lord. This is the first
Was received
on 30/10/24, my Lord. And the same has been forwarded to the company's office, my Lord, on the same day, that is on 30/10/24, and was received by the company's office on the 1st November 2024. And my Lord, I have annexed all the documents supporting the explanation, my Lord. So on the forward of the judgment and order, impugned judgment and order by the office of the Aizawl to the Silchar CHS on 6, it was received on 6/11/2024, my Lord. 6/11/2024. That is in my para number 2B of my application, my Lord.
Then
And then subsequently, my Lord, on 31/2025, the Silchar CCH had issued a brief note recommendation of the appeal. And as such, my Lord, 125 days had gone inadvertently, my Lord. And on 31/2025, my Lord,
starting from the day of 7/11/24 to 29/1/25. 7/11/24 to 29/1/25. Okay, then
and then subsequently on 31/2025, my Lord, the Silchar CCH had issued a brief note and recommendation of the appeal. That is on 31. The annexure is again on annexure number 3.
Then on 31/2025. What is Nero?
Nero is, my Lord, Northeast Regional Office, my Lord. And then subsequently on 31/2025, my Lord, this is on the same day, the Silchar CCH had forwarded the letter along with the original claim file with claim file and recommendation by the said Nero TP Hub. The Chief Regional Manager, New India Assurance Company Limited, the regional office had approached Mr. Kamal Kumar Bhatta, advocate, for his legal opinion on 6/2/2025, my Lord. And then thereafter, the legal opinion was duly prepared by the said advocate and the same was furnished to the Chief Regional Manager, New India Assurance Company Limited, Regional Office on 17/2/2025. And the same was received by the office on the next day, 18/2/2025. This annexure is at, my lord, annexure number 5. This is the legal opinion prepared by the advocate. So it is dated 17/2/25, and upon the left-hand top corner, there is a received date, 18/2/2025. That is annexure 5, my lord. And then, my lord, there's a slight mistake in this date. If I may, this para number F, 17/2, it should be 18/2. 17, it should be 18.
Yes, because only on 18 it was sent
My lord,
by the Chief Regional Manager.
it's in annexure number 6, that the date is in number 6. So on 18/2/2025, the manager and the administrative officer sent a recommendation note to the Deputy General Manager regarding the filing of the appeal, and the same was approved and agreed by the Deputy General Manager on, my lord, this is in annexure number 6. And as such, 153 days had elapsed inadvertently, my lord. And then on 24/2/2025, the NERO, that is the Northeast Regional Office, had sent back the claim file along with the approval of appeal to the in-charge Silchar CCH, and the same was received by the Silchar CCH on 3/3/2025. This letter is in annexure number 7, my lord. Annexure number 7. It was received by the Silchar CCH on 3/3/2025, which is in annexure number 7.
Yes, any objections? We'll condone it, 153 days. Because I think it has been explained, sufficient cause has been shown, along with all the documents.
Lordship, yes.
Yes, we'll hear on merit. Okay. It's better to hear on merit.
Anyway, Lordship, yes.
Yes.
Anyway, the judgment, it is interesting, Lordship, that they obtained the impugned judgment copy only after 1 month of pronouncement. It's interesting. Anyway, it's up to your Lordship. And thereafter also, your Lordship, then they take another 2 months, your Lordship, 2 months for taking decision as to whether they would file any appeal or not. And only for that, my Lord, they take 2 months for taking a decision, to reach a decision.
That's what I was also pointing out.
And thereafter, there are, yes, the correspondences which are now documented by the enclosed documents are all actually internal movements of documents.
Internal movements.
Yes. That take another 1 month again. And when it was forwarded to the council, Lordship.
No, these corporations and government machinery, they work like that.
And actually, more than 2 months have been lying delayed, my lord. Even after that, at the hands of the council again.
You contest on merit.
Okay,
That
okay,
is
that's
much better.
I
Because on technical grounds, again, this present application under Section 5 of the Limitation Act 1963 has been filed, praying for continuation of delay of 153 days in filing the connected appeal against the impugned judgment and order dated 27/9/2024 passed by the learned MACT, Aizawl, Mizoram in MACT case number 3 of 2023. Stop. Learned counsel for the applicant / appellant, Mr. Such and Such. Stop. The causes for the delay have been explained in the paragraphs 2 yes, in paragraph 2 of the paragraph 2 clause A to M, small a to M in within brackets, okay, paragraph 2 A to M of the application. Stop. The court has gone through the causes as reflected in the said paragraph, which has been supported by the documents at annexures 1 to 10. Annexures 1 to 10. Stop. The court, after perusing the documents as well as the pleadings in the application, is of the view that the applicant has been able to show sufficient cause for the delay of 153 days in filing the connected appeal. So accordingly, the application is allowed. Stop. And stands disposed of. Stop. Then in the main MSc appeal, learned counsel for the appellant is present. So learned counsel, Mr. Such and Such has entered your for respondent 1, isn't it? Entered appearance for respondent number 1. Stop. In view of the order passed in IA 87 of 2025, the present MSc appeal is admitted. Stop. What about notices?
My lord, all the notices are completed, my lord.
Complete.
My lord.
Are you filing any objection in the main appeal? In the main appeal?
I'll have to take a look, my lord. For that, my lord, if I may, can I be granted time, my lord?
Okay. Learned counsel for the respondent number 1 is allowed 3 weeks time to file objections if so advised. Stop. Call for the trial court records from the Motor Accident Claims Tribunal, Aizawl. Stop. List after 3 weeks.
Obliged.
Obliged. Item 10.
May I please, your lordship. My lord, we have filed affidavit in opposition, my lord. If your lordship permits, my lord, the hearing on condemnation may be taken up on 3rd of November, next week, Monday, my lord.
Third, learned counsel for the appellant, Mr. Such. Also heard learned counsel, Mr. Such, for sole respondent.
Yes, my lord.
For the sole respondent, who submits that the objection in IA 118 of 2025 has been filed. So it is prayed that the IA may be listed for hearing on 3/11.
Yes, ma'am.
3/11/2025. Stop. List accordingly.
Obliged, ma'am.
Item 11 and 12.
Please, Your Lordship. My Lord, this is an intervention application, my Lord.
Amendment.
No, intervention application.
Oh,
my Lord.
intervention.
We want to be added as a private respondent. Yes, in WPC number 103 of 2025.
Yes, any objection?
Hello, madam, the petition is an interim petition. I have just received the application this morning. After having a quick glance, I may be allowed to file written objection. I don't think it's necessary for them to intervene. It's a covered matter in fact. So what's the
No, depends if they are going to be affected by any order which is to be passed, then they need to be impleted. So anyway, you just you examine. Yes. Learned Counsel for the applicant in IA number 185 of 2025, which has been filed, praying for, where is your prayer portion? Praying for permission of this court for the intervener to be impleted as party respondent in the connected WPC 103 of 2025. Stop. The Learned Counsel for the petitioner, Mr. Such and Such, submits that he would like to examine the application as it has been received only this morning, and therefore prays for some time to file an objection if so required, if so advised. Stop. Learned Government Advocate Ms. Venice Yami is present. Stop. Also Learned Counsel Mr. For respondent number 6. Stop. List after 1 week? Yes. List after 1 week.
Deeply applies.
Part 2, item 1.
Yes.
Yes, my Lord. Lord, we can proceed.
Yes, you can start.
My Lord, before we proceed, my Lord, there is just one. I'm not sure, my Lord. We are more than ready to proceed, my Lord. But there is one thing, my Lord, that I have just a tinkling doubt, my Lord, is that because the appellant, the original appellant, my Lord, he has passed away. The original defendant also has passed away.
Okay.
Now the question is, my Lord, because they have been living there as close neighbors for so long, my Lord, we are ready, more than ready to take up the matter. It's not. I'm just wondering, my Lord, if this matter could be sent to a mediation or something like that, my Lord.
I was also just thinking because, yes, Learned Counsel, you are also not this. In fact, you have also taken some steps for partition of the LSC.
Yes. That
so,
we deny, my Lord.
So that which means that they are also living there, you're also there, and that is not denied by anybody. And in such matters, it's best to have an amicable settlement because you're going to be neighbors and you're going to be next door to each other, isn't it?
If they continue to live.
My Lord, we are.
No,
I mean, the reason I'm suggesting this
they
is
have been living and they are still in you're still living there.
Of course, my Lord.
Yes.
Of course.
My Lord, there have been more than one, not only once, but I think at least 2 times attempts have been made during trial, my Lord. And the matter also has been sent to this Lok Adalat. So, but,
That was before they died.
Yes, at that time when both of the
Before they were
parties.
still
The
there.
original, the
Yes,
original
the original.
parties.
So I
My lord,
think
in Mizo society, your lordship knows when someone dies, the whole neighbors, they help the person who has died, that family. These families also have been helping each other, my lord. So I'm just wondering if, because they're such close neighbors, I mean, we can make an attempt, my lord. If it doesn't happen, it can come back. We can have the hearing. But I am only suggesting, my lord, because I have this.
I understand.
believe it's
Because
possible.
this court also, I have also been thinking about it, and I thought they have been together for so long, and then any which way, whatever order is passed, it's going to be detrimental to the other party, obviously.
Yes.
And then again, another cause of action will arise, and then it will go on, the litigation.
My lord, for me, I think there won't be any chance again. Now, it's every attempt already been made, my lord. Though it's both of them went to the parties and.
What Learned Council is submitting is that was before the Lok Adalat was before they passed
I
away.
admit that it was, but what difference will it make? I cannot understand.
Because their respective wives, and in fact, I think with the appellant, it's only his.
My lord, what I'd like to, if I may, submit here is that once the matter has been protracted, my lord, it is drag on. Now it's been that this original case was filed way back in 2014, man. So now it's more than 10 years already. They now, if we keep on pending this matter, they are now wrongly enjoying, man. Actually, they are wrongly enjoying.
They cannot say wrongly also.
Now, my lord, that is why let's complete, my lord, whatever be the outcome of this matter. So I think it's time to call a day, my lord.
Because, my lord, the reason I'm saying is both of them, they were alive when this appeal was filed. But then they both passed away after the appeals were filed. In fact, my client, my lord, my original client, he passed away only, I think, this year. So before that, my lord, he was alive. So I can understand, my lord, them unwilling to settle because of their ego and all of those things. But now that it's, because with the appellant, if I'm not mistaken, my lord, it's his daughter who is living in his land. I might be mistaken, and with my case, it's his wife and daughter. So it's between different people now, not between the same people.
The case, my lord, is right from the start. It's
so substitution has also been done.
Substitution has been done.
Duly done, my lord. Duly done. Duly substituted. Both.
That is the reason why, my lord, I'm saying.
So in your case, who is now the son or the daughter?
The wife is the substituted party. Wife. Both of them are wife, my lord.
Oh, so only the wives are living now.
Actually, my lord, this case can never be allowed in law, my lord. As I submitted earlier, my lord, they have not challenged my LSC.
No, that's on the point of law. Obviously, that is the
That is
different
why, my
case.
lord, they are not good in points of law. That's why they are now suggesting that it may be applicable.
No, we are not.
That already attempt was already made.
In fact, my lord, if we were going to go to the point of law, my lord, what has happened is the revenue department themselves, my lord, have made
that they have
proper
not challenged the revenue department also.
and they have not challenged the process of that redemarcation, my lord.
No, that doesn't make any outcome, my lord. No outcome, no order out of that demarcation.
In fact, my lord,
no, nothing.
They were hiding that fact.
So let's finish, my lord.
Those are again new causes of action.
New causes of action.
Yes, redemarcation and all that.
Redemarcation.
Because that was never an issue in the original, before the original trial court.
But that was the reason why the court, my lord, in the lower, because the defense taken by my client, the entire defense was on the basis, my lord, that it was redemarcated by the revenue department and he had not objected. And it was on the basis of that defense, my lord, that the court in fact had passed the order. So it was not as if, my lord, this was a new fact which was never discussed in the lower court. The lower court, the entire judgment was based on the new re-verification which was done, my lord. So, and my learned friends, they have kept quiet about this re-verification in their plaint. They have not mentioned anything about this. But in our defense, my lord, in our written statement, we have mentioned all of these things. So that...
And in your additional documents,
yes.
What have you produced?
My lord, what we have produced was, because in our written statement, my lord, we had mentioned the redemarcation. And in our evidence also, we had mentioned the redemarcation of all of those, all the land. So the documents which actually shows the redemarcation of the land, that is what we had produced in our additional evidence. And my lord, the Supreme Court judgment is there. If I was supposed to argue, my lord, the Supreme Court judgment says, it's very clear that, my lord, this is what the Supreme Court judgment says, my lord.
As far as Order 41,
Rule 27.
Rule 27 is concerned,
yes.
If that was within your knowledge at that time, before the trial court, then you cannot raise it now.
No, it's
only if it was not within your knowledge you can raise it.
There are three things the Supreme Court had stated, my lord. In fact, the Supreme Court stated, my lord, in Sanjay Kumar Singh versus State of Jharkhand, my lord, reported in 2022-7 SCC 247. I have given the citation also, my lord. My lord, this is at page 249. 249, my lord.
Yes.
Paragraph number 7, my lord, in the bottom, it says like this, my lord. It is true that the general principle is that the appellate court should not travel outside the record of the lower court and cannot take any evidence in appeal. However, as an exception, Order 41, Rule 27 CPC enables the appellate court to take additional evidence in exceptional circumstances. It may also be true that the appellate court may permit additional evidence if the conditions laid down in this rule are found to exist and the parties are not entitled as of right to the admission of such evidence. However, at the same time, where the additional evidence sought to be adduced removes the cloud of doubt over the case and the evidence has a direct and important bearing on the main issue in the suit and interest of justice clearly renders it imperative that it may be allowed to be permitted on record. Such application may be allowed, even one of the circumstances in which the production, this is important, my lord, of additional evidence under Order 41, Rule 27 CPC by the appellate court is to be considered is whether or not the appellate court requires the additional evidence so as to enable it to pronounce judgment or for any other substantial cause of like nature. And then paragraph 8. As observed and held by this court in A. Adisami Chettiar versus A. Subaraj Chettiar, the admissibility of additional evidence does not depend upon the relevancy of the issue on hand or on the fact whether the applicant had an opportunity for producing such evidence at an earlier stage or not, but it depends upon whether or not the appellate court requires the evidence sought to be adduced to enable it to pronounce judgment or for any other substantial cause. It is further observed that the true test, therefore, is whether the appellate court is able to pronounce judgment on the materials before it without taking into consideration the additional evidence sought to be adduced. So, my lord, the law is, this is the law, my lord. So what I'm trying to argue, my lord, is that if we were to argue this case, I don't want the parties, my lord, to be in a very bad situation. If I was to argue this case, my lord, there is a chance, I'm not going to ask your lordship to reveal your lordship's decision on this point, but there is at least some chance, my lord, that this additional evidence can be considered by this court. In light of all of this, my lord, at this stage, because in fact I am from that locality, my lord, I know the area where they live. So the reason I'm saying is, my lord, so that no one will be kept in a very, very bad situation, in a very painful situation. And so if we were to make them mediate, perhaps, my lord, that could give them a better outcome. Because if your lordship will see the additional evidence submitted.
No, but for the court to send it for mediation, both parties have to agree. So the appellant is not agreeable.
The appellant's counsel is not agreeable, my lord. Perhaps he can take instructions, my lord. Because as counsels...
Yes, learned counsel, can you take instructions and come tomorrow?
My lordship, yes, the Can very well be done, yes, if Your
Yes,
Lordship
because who knows,
insists on
the,
it.
now the wife may be having a different view of the matter.
Malik. Then, okay, let's fix it again for tomorrow, my lord.
Tomorrow.
In the meantime, I'll take instruction from my
Yes.
Yes.
Pass over for the day in order to enable the councils to take instructions as to whether they would be willing to refer the matter for mediation.
Tomorrow, can we upgrade it to part 1, my lord? Part 1 hearing, my lord. Tomorrow.
It's already here, my lord. It's not like we.
It's already there in the list
Madam.
and as part
Only
third
that-
and listed as part third,
Yes,
item
only
number
that we
1.
can upgrade it to part 1, that's
No,
all.
no, I'm keeping it
Madam.
in as number 1 in
Madam.
the part 2 list.
Oblige.
Item 2.
Excuse me. Skip this in the file.
Yeah, please, Your Lordship.
Yes.
Your Lordship, this appellant, Mr. Cedar Insang, 29 years.
You're
resident
appearing
of,
as amicus, not
No, my lord.
amicus.
resident of Buang Village, Champhai District, sumo driver by profession, was arrested on 9/2/2022 by ASI Lutlan Chua at Khankon police check gate at the outskirts of Champhai.
Let us see the FIR.
Fire.
Page 1. Page 1 of the paper book. Yes, please read the FIR.
Your Lordship.
Yes.
To the officer in charge, Police Station Champhai, subject FIR. So I beg to state that on 9/2/2022 at around 8 p.m., while I was on duty at Chal Boya Junction, Khankon Police Check Gate, 5 soap cases containing brown powder suspected to be heroin, weighing 63 grams, value of rupees 2.5 lakhs in local market, and 10,000 pink tablets suspected to be methamphetamine, value of rupees 30 lakhs in local market, were recovered and seized from one vehicle sumo, Aizol to Zokathar service, BR registration number MZ01J8821, driven by Silarin Sanga, 29 years, son of Sil Pek Thang of Buang village. The recovered contraband items and the vehicle were seized in the presence of reliable witnesses by observing all formalities. The accused was apprehended and brought to the PS along with the seized contraband items. I therefore request you to kindly register a case against the accused person Silarin Sanga, son of Sil Pek Thang of Buang village, Champhai, under appropriate section of law.
then your grounds.
Your Lordship, number one is no civilian witness at the time of the alleged search and seizure on 9/2/2022.
1 minute, 1 minute.
Your Lordship, even though the case IO cited 2 witnesses in the charge sheet, namely
Number
Mr.
1, no civilian witness to the seizure. For
Yes,
the
my
seizure.
lord. Even though the case IO cited 2 witnesses, Mr. Chanchin Moya and Mr. Jacob Landunrima. Mr. Chanchin Moya, one of the witnesses cited by the case IO, was examined in the court. He was examined on 27/1/23 as PW number 2. His examination is page number 25, Annex 10.
You first state the grounds and then after that go to the evidence. You first
Yes, sir.
just go one by one, the grounds, and then after that go to the evidence. Okay, that is better,
Yes,
more
sir.
systematic. So number 1 is there were no civilian witnesses to the seizure.
Yes.
Then
Because this, the lone witnesses stated that
that there is no one.
there was no one. And when he stated that when you reached the place of occurrence, the contraband items was already unloaded, it was already inside, kept inside the police check gate. So nobody saw the appellant carrying the contraband items.
Okay, so that is PW2.
PW2, the lone witness, the lone civilian witness. And the next is the prima facie that the appellant knowingly carried the contraband items was not proved by the prosecution. In fact, the PW number 1, the seizing officer ASI Tlanchua, SPW number 1, deposed before the court that the accused person is not the owner of the contraband item. He clearly stated that the seized article did not belong to the accused person.
PW, who stated PW5?
PW1,
Oh, PW1.
the seizing officer. And next point is, Your Lordship, no videography was taken at the time of the recovery.
For that, this is before BNSS, isn't it?
Before BNSS.
So it's okay.
But that was in violation of Drugs Law Enforcement Field Officers Handbook.
Yes.
And the next point is, no sample was drawn at the place of occurrence. And there's no record, there's nothing on record to show that sample was drawn, Whitman was taken at the place of occurrence at the police check gate at Khankon.
Yes.
Next point is, Your Lordship, the sample examined and tested in the FSL is very less. Only 120 mg of heroin was sent to the FSL. And only 2 tablets, that is 180 mg of meth, was sent to the FSL.
Sample was not as per the Act.
Standing order, Your Lordship.
Standing order.
Yes. The standing order says it has to be at least 5 grams. So these are the main points that we have, Your Lordship.
Okay. So now let's go to the evidence. Page 4. Page 4, PW1. Who is PW1?
ASI Tan Chua,
No, seizing.
seizing officer.
Just read PW1's deposition.
I know the accused person. I stood before this court today in my capacity as a complainant. On 9/2/2022 at around 8 p.m. while me and my party were on duty at Chalboyas Junction, Khankong Police Check Gate, 5 soap cases containing brown sugar suspected to be heroin weighing 63 grams and 10,000 pink tablets, 5 bundles, weighing 1.095 kgs suspected to be methamphetamine were recovered and seized inside 1 mustard leaves bag from 1 Sumo Aizol to Zokota service. BR number MZ01J8821, driven by Silrin Sanga 29, son of Sil Pekthang of Wong village. The recovered contraband items and the vehicle were seized in presence of reliable witnesses by observing all legal formalities. The accused was apprehended and brought to the police station Champai along with the seized contraband items. Then I submitted a FIR to OC Champai for registering a case.
Stand across. It is a fact that the accused is driver of the vehicle. What about the other passengers? There were other passengers also.
Yes, Your Lordship.
Did any of them depose?
No.
No. Okay, so PW1 said that the present accused is not the owner of the seized article. I deny the suggestion. Okay, then PW2. Who is PW2? Seizure witness.
Chichan, yes, Mr. Chachin Moya. She's a witness.
He is the civilian.
Civilian witness, Your Lordship.
Yes.
He's the lone civilian witness.
Please read PW2.
I know the accused person. On 9/2/2022, I was present at the spot, that is Chalboya Junction, Khankon, Police Check Gate, Champhai. Well, Champhai police personnel recovered and seized 5 soap cases containing brown powder suspected to be heroin, weighing 63 grams and 10,000 pink tablets, 5 bundles suspected to be methamphetamine, weighing 1.095 kgs from one person, namely Silorin Sanga, and weighman of the SA were done on the spot. I gave my signature on the Caesar memo. Exhibit P2B is my signature on the body of Caesar memo. Here in the cross-examination, at number 3, cross-examination number 3, he stated that it is a fact that weighman of the seized methamphetamine was not done at the place of occurrence.
The bag containing mustard leaves from where seized article were recovered already
Yes.
unloaded.
The bag containing mustard leaves from where the seized article were recovered is already unloaded from the sumo and was detained inside police Khankon check gate. There is a police house just beside the road in that place.
It's already unloaded.
And he also stated that at the last para,
It is a fact that when I
reached the place of occurrence, there was no other civilian witnesses.
Okay, then PW3 is the expert, PW4.
Is a FSL.
It is a fact that the weight of the samples were all under 1 gram. PW4. Okay, then come to PW5.
PW number 5 is case,
PW5 is the IO.
case IO.
Please read PW5.
Yes, Your Lordship. I know the accused person. I stood before the court today in my capacity as an investigating officer in the instant case. In connection with the instant case, the case was endorsed to me for investigation. I conducted an investigation and I have proved the guilt of the accused as follows. I have examined and recorded the statement of the seizing officer who stated before me that on 9/2/2022 at 8 p.m. he seized 5 soap cases of heroin weighing 63 grams from the possession of Silorin Sanga. Here, Your Lordship, he stated that he had examined and recorded the statement of the seizing officer, but on perusal of the case record, the statement of the seizing officer was recorded by the seizing officer himself. And the next para, I have also examined and recorded the statements of the independent civilian witnesses, that is Chanchin Moya and Jacob Lanun Lima, who stated before me that they had witnessed seizure, recovery and arrest with their own eyes. These witnesses' statements were also not recorded by the case IO. They were recorded by the seizing officer. I have also examined and recorded the statement of the accused who admitted his guilt.
And he said that he examined 2 civilian witnesses, but there is only one.
There's only one who was not even present at the time of the recovery
At the time of the recovery.
Yes.
Then Or the accused examined himself also as DW.
Yes, Your Lordship.
Please read this, DW.
I am accused person in the present case. I am a driver by profession. I drive sumo bearing registration number MZ01J8821, which was owned by Puzo Mashwaya of Zokotar. On 9/2/2022 at around 6 p.m. while I was about to leave Zokotar towards Aizawl by my sumo, two persons, one is female and the other is male, came to me and they requested me to deliver 2 bags of mustard leaf to Aizawl. I asked them to load her mustard leaf bag on the carrier of my sumo, and I did not have time to check the content of that bags of mustard leaf. The owner of the said mustard leaf bag said that the same would be taken by some person when I reached at Aizawl counter. The mobile phone number and name women was pasted at the said mustard leaf bags. After that, I was headed towards Aizawl along with my passengers as usual as before. At around 7:30 p.m., we reached Champai Police Check Gate, Khankon. Then the police had checked my sumo and belongings. Surprisingly, the police had found some packets of methamphetamine and heroin from a bag of mustard leaf which was not known to me. The police arrested me and my sumo along with meth and heroin. When the police personnel arrested me, they asked me to call the phone number written in the mustard leaf bags. I called it and the same was picked up by one man. The person who picked up my phone call said to me that I will take the mustard leaf bags when you reach Aizawl sumo counter. The weightman of the said seized methamphetamine and heroin was not taken in my presence. I had no knowledge regarding the said seized articles as I had not checked the said bag at the time of loading on my sumo. It was a part of my work to carry some luggage from others without checking what they kept inside the bag. I am innocent in the present case, and I prayed before this honorable court to acquit me from the charge framed against me for the ends of justice.
Okay, and where is the impugned judgment? Page 35. Do you have a copy of the standing notification?
Yes, Your Lordship.
Yes, just supply a copy of that also. Yes, PP. First of all, the foundational facts have to be first established by the prosecution regarding the seizure and the conscious possession.
Your Lordship, it is the contention and the grounds of my learned friend that the seizure memo is not prepared by the seizure officer. Yes, it is true that the seizure memo and arrest memo is prepared by the IO. But then if we see page number 19 of the paper book, Your Lordship.
19?
19, yes.
19.
Your Lordship will see that in the subsequent page, page number 20, the seizure form, even though he have stated in his cross-examination that under section 57 NDNPS, I do not prepare the report of seizure and arrest. But then under section 165 CRPC, he have duly prepared the seizure form, property search and seizure form. This PW number 1 is Laltlan Chua, who is the seizing officer. In page 20.
So you're referring to page 20?
Yes.
This one seized in my presence.
On the
bottom right.
on the bottom of the page, Laltlan Chua, ASI.
This is the IO.
This is the PW number 1, the
Oh, this is
seizing
the
officer.
seizing officer.
Yes. Even though they have, my learned friend have taken the stand in page number 5 of the paper book, this is the cross-examination of the seizing officer, wherein he has stated that in second paragraph, I did not prepare report and seizure of arrest under section 57 of NDNPS Act. Now that could not vitiate the trial because it was duly prepared, the seizing form, property and of search and seizure form was duly prepared by the seizing officer.
But what about seizure witness?
Seizure witness is there. The 1 and 2 is there. Your Lordship. In
But
the
have
same
they been
page, page
examined?
number.
Have they been examined?
Only 1 is examined. Even though we are not an expertise on signature, if on comparison of page number 6 and page number 20 of the paper book, you will see the seizure witness number 1, PW number 2 is the witness number 1.
Okay.
Yes.
But PW 2, he said that the seized article was already unloaded from the SOMO and was inside the police jacket.
Correct.
So he did not see the seizure.
Your Lordship, he just stated that when I reached the place of occurrence, the bag containing mustard leaves from where the seized articles were recovered is already unloaded from the SUMO. But then he did not state as to the occurrence, the time of occurrence when the seized article was taken out from the bag of the mustard leaves.
No, he said when he reached that place.
Yes.
That means when he reached the place of occurrence,
Yes.
that bag was already recovered and unloaded. So that means he did not see the seizure. He did not see the seizing officer recovering the seized article from the accused. And he is the only one who has deposed.
Yes,
The other
yes.
seizure witness has
Correct.
not deposed.
Correct.
So which means the seizure is not proved.
Your Lordship,
See, the NDPS Act is such a technical
Yes,
act,
technical.
and each and every,
It has to be
step,
proved
the
beyond
procedure
dispute.
has to be done in accordance with the Act, strictly in accordance with the Act.
Yes.
You know the law, so I need not say much. And even regarding the samples, even the samples have to be according to the standing notification, the amount
5
So
grams.
here, yes, they said that even the expert, the official expert, he has clearly deposed that it was all under 1 gram. So even that was not drawn according to the mandated weight which is supposed to be sent to the FSL.
Yes.
And 313 statement also, the accused has clearly stated that it was given to him
By
and he
someone
did not
else.
know what was inside. So which means the conscious possession was also not proved. And only when conscious possession is proved, the reverse burden will come.
Section 30.
I think it is not well investigated.
Yes. And
So many loopholes are there.
Your Lordship, I should not be saying this, but then the weighment of the
Weighment.
weighments in PW number 2 have the sole witness have stated that weighment was not done at
Was
the place
not done at the place of occurrence.
occurrence, and the DW number 1, that is the appellant himself, said that the weighment was not done.
It was not
at
done
place.
at the place. That also is another ground.
We'll leave it to your wisdom, Your Lordship.
Okay. No, not this. There is a notification regarding the samples. How much? If it's ganja, this many has to be drawn sample. Just that one, that notification. Ah, yes. I think it's this one.
It's 5 grams in the instant case.
Yes, 5 grams. 5 grams in respect of all narcotic drugs. And in case of opium ganja, it should be 24 grams in each case. Heard learned counsel for the appellant, Shri such and such, stop. Also heard Miss Mary L. Kempte, learned public prosecutor for the state of Mizoram. Hearing is concluded. Judgment reserved.
Duly obliged.
Item 12. Oblige.
Yes, my lord. This is an jail appeal, my lord.
Okay.
I'm the amicus for the appellant. So, my lord, this jail appeal is against the conviction under 307, 326, and 324 of the IPC, wherein he has been convicted and sentenced to undergo under 307 8 years and fine of 5,000,
5,000
and in default another 5 months. And under 326, 7 years,
7
and a fine of 10,000, and in default of another 3 months. And under 324, 2 years and a fine of 1,000, and in default another 2 months. So, my lord, if I may take your lordship straight to the FIR, which is at page 1 of the paper book. Page 2 is a translation, my lord. If I may read.
Yes.
So today, that is 5/9/2023 at around 5 p.m., my younger brother, Lalnama, 31, son of so-and-so, laid a hand and tried to kill my parents. He initially searched for a knife, and since he was not able to find it, he went for the wooden pestle and hit a blow on their head. They were bleeding, and hence they have to be taken to the hospital as they are both aged.
This incident weakened their body to a great extent. With this being the situation, I pray that the harshest punishment be awarded to him as per law. So, my lord, the complainant is the elder brother of the accused appellant, and both the victims are the parents, my lord, father and mother. So, if I may take your, and charge was framed on 8 December 2023, which is on page number 3 of the paper book. Under 307, 326, and 324, and he did not pleaded guilty and came for trial. During the trial, 7 prosecution witnesses has been examined. If I may take your lordship straight to the evidence of the PW number 1, who is the complainant, which is on page 10.
Yes.
If I may read. I am the complainant in the incident case, and the accused, Ephraim Lelnama, is my younger brother. My mother, PW number 3, my father, PW number 2, and the accused person are living together under the same roof at Bongkon Brigade, Aizawl. The accused person used to assault my parents several times, as he is an alcoholic, and he usually gets angry when he is intoxicated with alcohol. On 5/9/2023 at around 5 p.m., the accused person got drunk and very angry as he did before. He tried to eat lentils, dal at the kitchen. PW number 3, who is the mother, asked him, "So, haito arwalin so loila," which translates to, my lord, let's eat the dinner together.
What does that mean? Let's have dinner together.
Yeah, yes, my lord. It's almost time for dinner. Let's have the dinner together, all together. The accused person then threw the said lentils along with the pot outside the kitchen window. The accused person then immediately shouted, "Kathat don," which translates to, "I will kill you all," and immediately grabbed a pestle, miso soup, and proceed to hit PW3 at the back of her head. So, my lord, the weapon used here is the pestle, which is a wooden stick used for grinding chutneys and all. After the accused person hit PW number 3, PW number 2 then immediately proceeded and tried to stop the accused from continually hitting PW number 3, and in the process, the accused hit PW number 2 a couple of times, and the injury sustained to the PW number 2 and 3 could clearly be visible. I do not remember the exact year. It was around 2022 or 2023. The accused tried to strangle PW number 2 at their residence at Bongkon Brigade, Aizawl, and almost succeed. The accused often threatened PW number 2 and 3 previously before this incident countless times. One of my relatives informed me about the incidents as PW number 2 and P3 were taken to Greenwood Hospital, Aizawl. As such, I proceed toward the said hospital and inquire about the matters. Thereafter, I lodged FIR before Bongkon PS and cross-examination by the defense counsel. I have 7 siblings. The accused is the youngest amongst my siblings. I am married, and now I and my family live in Bongkon Lunglei Road, Aizawl. After I got married, I have separated establishment since 2009. The accused is also married, but he divorced his wife. Since I am not live together with the accused, I could not say the exact month he divorced his wife. When I and the accused used to live with our parents, the accused used to consume liquor, but he never used to assault them because during that time he was very young. I know that prior to the alleged incidents, the accused used to assault my parents under the influence of liquor. It is not a fact that the accused never assaulted my parents before these alleged incidents. It is a fact that whatever I knew about the alleged incidents is derived from my parents. It is not a fact that I am deposing falsely before the court today. So, my lord, this is the evidence of the complainant PW number 1. And my lord, from here, the PW number 1 was not at the time of the alleged incidents, my lord. And he only heard the incidents from his, yes, my lord. And page number 12 is the PW number 2, who is the father of the accused, the victim. The accused person is my youngest son, and we are living in the same roof at Bongkon Brigade. On 5/9/2023 at around 5 p.m., the accused person got drunk when he arrived at the residence, and he proceeded to the kitchen there by eating lentils dal. During that time, my wife PW number 3 asked him, "So ay to arwal lolo in arwal in so ay lolo ila law ay big su kan kham lawang," which translates to, "My lord, it's almost time for dinner. Let's have the dinner together, and don't finish yourself, my lord." The accused person then threw the said lentils along with its pot outside from the kitchen window. The accused person shouted toward us, stating that "Kathatvek don't you," which means "I will kill you all," and immediately took the pistol and hit PW number 3 at the back side of her head. When I tried to stop the action of the accused person as he continually hit PW number 3, the accused person then started hitting me on my head for several times till I got fainted. I do not know how many times the accused person hit me due to the reasons I got fainted. At the first time, he hit me by using pistol. When I regained consciousness, I could see the people from our surrounding neighbors had attended to us. If it were not for them, I genuinely feared that he could have killed us. Previously, the accused person had threatened us about 3 times by making a remark stating "Kathatvek doncho," which means "I will kill you all." The accused person had previously tried to kill me by strangulation. I survived only because my wife and my daughter had intervened. The accused person often created troubles and physical violence when he got drunk and assaulted me and my family for several times before these incidents. I would like to testify that the accused person has no other option except a resident for went back home, and as such is not safe for our life to release him on bail or discharge or acquit in connection with the incident case. The CMR number so-and-so produced before this court is a pistol used as a weapon by the accused person during commission of the crime. Cross-examination. The accused is about the age of 31. Although he got married, he divorced his wife prior to the incidents. It is a fact that the accused person is a habitual drinker. He on various occasions would come home drunk. It is a fact that during the alleged incidents, the accused person was drunk. It is a fact that he maintained a well-behaved character when he is not drunk. I accept the suggestion that if he was not under the influence of alcohol, the incident might not have happened. It is a fact that the accused person took the pistol out of anger after PW number 3 approached him and passing verbal conversation. When the alleged incidents happened, I was present in the same room as the PW number 3 and the accused. It is a fact that the alleged incident started and to which the accused person confronted PW number 3 and myself due to sudden provocation. It is a fact that I did not lodge the complaint. The complaint was lodged by PW number 1. It is a fact that if the complaint was not lodged by PW number 1, the incident case would not exist. It is not a fact that I am falsely deposing falsely before the court today. Re-examination. Regarding the whole content of my cross-examination, I would like to explain that we did not make anything which can anger the accused person. This was the evidence of the PW number 2, my lord, the father who is the victim, my lord. And PW number 3 is the mother who is also the victim of the incidents, my lord. The accused person is my youngest son, and we are living in the same roof at Bongkon Brigade, Aizawl, on 5/9/2023 at around 5 p.m. The accused person come home drunk and try to eat lentils dal. I say to him, "It's almost time for dinner. Let's have the dinner together. Don't eat yourself." Enraged by this, the accused person threw the pot of lentils out of the window. Then the accused person took the pistol and came toward me, hitting me on the backside of my head, and lost consciousness after that. When I regained consciousness, I was told that after hitting me, the accused person also hit his father, PW number 2, while he tried to stop his action. After that, people from our neighborhood. We already there, and they took me and my husband to Greenwood Hospital Aizawl. The accused person often assaulted me before this incident, and he tried to kill PW number 2 for several times. If the accused person is released or discharged or acquitted in this case, I have strong reason to believe that he will take revenge and assault me and my family. Therefore, it is not safe for our life to release the accused person from jail. Cross-examination. It is a fact that the accused person is a habitual drinker. He on various occasions would come home drunk. It is a fact that during the alleged incidents, the accused person was drunk. I accept the suggestion that if he was not under the influence of alcohol, the incident might have not happened. I accept the suggestion that the accused and myself due to sudden provocation. It is a fact that I did not lodge the complaint. The complaint was lodged by PW number 1. It is a fact that if a complaint was not lodged by PW number 1, the instant case would not exist. It is not a fact that I am deposing falsely before the court. So, my Lord, my humble submission regarding the evidence of the PW number 2 and 3, my Lord. From the surrounding circumstances, my Lord, I accept the fact that the appellant is the troublemaker, my Lord. He was an alcoholic at a very young age.
They are the injured witnesses, 2 and 3.
Sorry, my Lord.
They are the injured
Yes, my
witnesses.
Lord. Yes, my Lord. And my Lord, that the incidents happened only due to the momentary lapse of control, out of control of the appellant, my Lord. He did not. There was no repeated blows, my Lord. I will come to that, my Lord. And there was no prior preparation, or there was no intention to commit the murder, which is defined under 300 of IPC, my Lord. There was no attempt to commit a murder. And my Lord,
Who is PW4?
PW4 is the Caesar witness, my Lord. And it was not contested, my Lord, regarding the Caesar witness. If I may skip to the IO, my Lord, who is PW number 6. Page 18 of the paper book.
Who is PW5?
PW number 5 is also Caesar witness,
Also
my Lord.
Caesar.
6 is the doctor who examined the injured victim, my Lord.
PW6 is the doctor.
If I may read, my Lord. I am the expert witness who conducted medical examination of the 2 victims on 5/9/2023 at around 6 p.m. While I was on duty at Greenwood Hospital, Aizawl casualty, some NGO leaders of Bongkon brought 2 injured persons, namely Zhou Sangzoli and Vanal Sang, as they were brutally assaulted by their son Ephraim Lalhama. Thereafter, the police personnel of BK Bongkon Police Station also arrived at Greenwood Hospital to investigate the case. I conducted medical examination on the victim, Zhou Sangzoli. My findings are as follows. Date and time of the incidents, 5/9/2023, 5 p.m. General condition, conscious and oriented. Injury report, laceration 7 into 2 centimeters on occipital region head. In my opinion, the nature of injury is simple injury. After I conducted medical examination on the victim, Vanal Sang, my findings are as follows. Date and time of incidents, 5/9/2023, 5 p.m. General condition, conscious and oriented. Injury report, laceration 3 into 1 centimeter on occipital region. History of dimming of vision. The victim lost his consciousness after the incidents around 5 minutes. In my opinion, the nature of injury is grievous in nature, as the victim was in the state of loss of consciousness for 5 minutes after the incidents. My Lord, this report cannot be a conclusive proof to it does not attract any of the 320 of the IPC, my Lord. Any heart that designated as the grievous in nature, my Lord. Only because he lost consciousness, he cannot be grievous in nature, my Lord. cross-examination, it is a fact that neither of the victims had been admitted in the hospital due to the injuries sustained by them. It is not a fact that I am deposing falsely before the court. So, my lord, they were not even admitted at the hospital. They were given first aid and they were released, my lord. So, conviction under 326 cannot be sustained as well, my lord. And PW number 7 is the case IO, my lord.
According to you, the injury was not grievous.
Yes, my lord. Both the injury should be simple injury, my lord. It does not attract any of the section 320 of the IPC. And
Then IO is PW7.
yes, my lord, page 23, my lord. On 5/9/2023 at 6:50 p.m., a written FIR was received from Lan Helena, son of Van Sang of Bongkon so-and-so. His younger brother, Lan Nama, son of so-and-so, has assaulted his parent with having attempt to kill them by hitting both their head and pestle. Accordingly, the complainant requested to take necessary action, and hence Bongkon Police Station case number so-and-so was registered, and the criminal case was duly investigated into it. After my superior officer done all the necessity required by law of my investigation, I conducted the investigation. During the course of the investigation, the PO was visited and sketch map of the PO was drawn. The complainant, Al Helena, was carefully examined and recorded his statement, which is enclosed in separate sheet. On examining the complainant, he stated that while his younger brother, Ephraim Al Nama, took up their career of cook pulse from their kitchen, his mother told him to wait for the time of dinner, which was detested by his younger brother, so that he threw out the cook pulse curry along with its vessel from the windows, saying words, "I will kill you all." He took up one pestle being designed by his father and hit his mother's head. While his father was moving to help his mother, his brother hit his father's head twice. Moreover, the accused, Ephraim Al Nama, was formally arrested by preparing arrest memo so-and-so, and he was thoroughly interrogated and recorded his statement. He admitted that he assaulted his parents by hitting their heads and with one pestle. The accused looked for a blade weapon first. However, he found no blade weapon. He picked up the said pestle instead and then assaulted his parents. While visiting the PO, the pestle was also seized in the presence of two civilian witnesses and kept in PS Malkhana, white Malkhana registration so-and-so for the purpose of evidence. The two Caesar witnesses were also examined and recorded the statement. Furthermore, the two victims, Van Sang and Pizao Sang Zuali, were also thoroughly examined and recorded the statement, which are enclosed in separate sheet. Soon after, they got hit from their son. Both victims were unconscious and their neighbors saved them from the brutal actions of the accused person. Both the victims also stated to me that the accused person often created domestic violence and assaulted them for several times before these incidents. Thereafter, medical treatment and examination for both the victims was done at Greenwood Hospital, Aizawl, where they were immediately evacuated to the two before making reports to the police. The MO, the Greenwood Hospital, Aizawl, considered the injury of Van Sang as grievous in nature, which was reflected in the medical report. All available witnesses were examined and recorded their statement. Under the above facts and circumstances, a prima facie case under Section 307, 326 IPU was found well established against the accused, Ephraim Al Nama, and as he undoubtedly admitted his guilt of brutal act upon his parents, which could have certainly killed his parents. Besides, his use pestle was a dangerous weapon to kill a human being. The exhibit MO produced before this honorable court is seized the weapon in connection with CMR, and the same is seized by me during the course of examination. Therefore, I pray this honorable court to punish the accused person as per
provision of law. Cross-examination. At the time of the occurrence of the incidents, apart from the accused and his parents, no other person were present at the PO. As far as I know, at the house of Pulal Nelian, apart from the accused and his wife, his granddaughter living in his home. I do not know the whereabouts of the granddaughter of Pulal Nelian at the time of the incidents. Soon we received the information regarding the incidents. I and my team rushed to the PO. However, 2 victims have been taken to Greenwood Hospital, Aizawl, by their neighbors. Thereafter, I approached Greenwood Hospital, Aizawl, and attended the 2 victims. It is the fact that the victims were not admitted at the hospital. They have been discharged after they were given first aid. When I reached the hospital, the injury of the victim were covered with bandages by the attending nurse. It is a fact that I personally do not know the number of injury sustained by the 2 victims. At the time of recording the statement of the victim, they were both conscious. It is not a fact that the accused did not admit his guilt. It is not a fact that I did not find a prima facie case against the accused person. The accused has been wrongly implicated in the instant case at the instance of the complaint. It is not a fact that I am deposing falsely before the court. So this was the evidence of the IO, my lord. The accused appellant was examined under 313, which is at page number 5 of the paper book, where he denied the allegation of the alleged incidents, my lord. And as he do not have any knowledge, as he was intoxicated at the time of the incidents. He denied all the question for his explanation, my lord, by stating that he does not have any knowledge as he was intoxicated. So, my lord, my humble submission is that it was their youngest son, my lord, who has been living with his parents and no one else, my lord. If he had an intention, my lord, during that alleged incidents, my lord, he could have hit several blows. There was no one there at the time of the incidents, my lord. He could have hit them, but only a single blow to each of the victim has been given to has been hit by the accused appellant, my lord. And regarding the weapon used, it was a pestle, which is a wooden, and there was no description regarding the weapons.
So according to you, the conviction under 307
yes, my
cannot be
lord.
sustained.
Yes, 307 and 326 cannot be sustained. Cannot be sustained. The only conviction can be made up is under 324. 324, my lord. And my lord, regarding that, both the victims are who age about 70 years, my lord. Since even though their son has committed has sustained an injury from his son, but my lord, they have unconditional love for their son, my lord. They wanted their son to be released from the jail custody, my lord.
How many years has he been?
2 years and 1 month and 22 days. And my lord, there is also a letter. There is also a communication letter between the victim and the appellant, my lord. Even though this is an appeal, my lord, apart from the
letter from?
A letter from the jail and the parents of the accused appellants, my lord,
Saying what?
saying that they have already apologized the actions of the accused appellant and wanted to reduce his jail term, my lord, because he was the only who was looking for his parents, my lord.
He has been now incarcerated for 2 years, 1 month.
And 22 days, my lord, till date. If I may submit this letter, my lord. The translation is at the backside. The translation is at the backside.
Yes, PP.
Your Lordship, with regards to the letter that is sent by the parents, I do not have any comment.
That is outside the records.
Yes. Your Lordship, I did not put any citation, but then if with Your Lordship permission, I will make the citation and submit it later. Because
citations on what point?
Intentions.
intention.
Yes. I'm going to make 2 citations. It's 2025 SCC online, SC. I will
You
go
just
as
apply later.
yes. I will go as on the ground. First, in page number 6, question number 4. This is the 313 questions. This is page number 4. The appellant have admitted his guilt. Question number 4.
Yes. It is incorrect. This one. In 313, page
Yes,
6.
question number 4. It is incorrect that I often assaulted or threatened them. I used to get all crazy when I am drunk. I deeply regretted my action. It's neither here nor there, but then he did not say that he did not do it also. But then if this has to be read with
No.
page number 52.
Learned PP, the fact that he hit them,
yes,
that is already proved.
Yes.
Because PW2 and PW3 are the injured witnesses.
Yes.
And the injured witnesses
These are
have
the
already
witnesses
stated
themselves.
that he hit
Yes,
them.
yes.
So that is proved.
Yes.
Now the only question is whether it will come under 307 and whether it will come under 326.
Yes.
That is the only point now.
And Your Lordship,
because the doctors, the medical report, I think that is only simple
Simple,
injury.
yes.
Because even the IO, in his cross-examination, he stated that the victims were not admitted at the hospital. They have been discharged after they were given first aid. So the same day they were discharged. So which means injury was not serious also.
Yes. Your Lordship, anyway, if I may take Your Lordship kind attention to page number 62 of the paper book. This is the details of property seized. The weapon used here is that of Your Lordship might be
That
aware of the
pestle.
mortar and pestle.
Yes, yes.
That wooden one.
Yes, wooden one to grind the chutney.
Yes, to grind the chutney, but it's 1.5 feet long. 1.5 feet long will be about this much, about the size of my file of long. And then when causing a huge blow, then I'm pointing out this Because the citation that I am going to use, the weapon used, whether it's dangerous or not.
Dangerous or not.
Yes, that is the question. So the weapon used here is that mortal, that pestle about this thick, this miso soup thick. It's as much as this much thick and 1.5 long. So we cannot consider it as not dangerous because it could cause fatal injury to the victim. And Your Lordship, the other ingredients is intention has to be proved. Intention has to be proved. In this regard, I'm going to cite 2025 SCC Online SC 807 Para 12. (2025) SCC Online SC 807 Para 12.
807.
Yes. This is with regards to the intention.
Intention.
And Your Lordship, yes, Your Lordship has already pointed out there are witnesses, like two victims together.
Yes, two victims are
and
dead.
this is in corroboration with the FIR that was submitted. PW number 1 is the complainant, who is the brother of the appellant. Even though he only make his statement or deposition before the learned trial court, but still it corroborates with the evidence of the PW number 2, number 3 and the FIR. And Your Lordship, we know that he also admitted that he's a habitual drinker. And the mother feared him. And with regards to intention, I will just point out the portion that I would like to highlight. PW number 2, re-examination. PW number 2, re-examination is in page number 13. Reading the whole content, I would like to explain that we did not make anything which angered the accused person. So there was no provocation. When there is no provocation, the intention to cause grievous hurt is clear. And page number 12. In page number 12, the last paragraph, Your Lordship. This is not the first incident. The accused person, in the last paragraph, second line, the accused person oftenly created troubles and physically violent when he got drunk and assaulted me and my family for several times before this incident. And on the same page, second paragraph, third line from the last, the accused person shouted towards us, stating "Kathat vek don cheu," and immediately took the pestle and hit PW number 3 at the back side of her head. That means "Kathat vek don cheu" means I'm going to kill you all. It's not translated here, but then the meaning of "Kathat vek that" means kill. Kah means me. I am going to kill you all. So he knows what he did. The intention is very clear. And taking the miso pestle, he could have taken, say, for example, a bottle of water and then hit it. Then it might lead to a small injury. But then the intention is very clear. He says that with the intention of killing, I'm going to kill you all. He have made the attempts before also. I have taken Your Lordship to that. He have made the attempts before. Now on that given day, he stated that without provocation, he said that I'm going to kill you all. And then he took the miso soup and then hit his mother. So that is the incident. And Your Lordship, in page number 14, this is the position of PW number 3, that is the victim herself. Third paragraph, the accused person often assaulted me before this incident, and he also tried to kill PW number 2 for several times. May I continue, Your Lordship?
Yes.
If the person is released and discharged or acquitted in this case, I have strong reason to believe that he will take revenge and assault me and my family. Therefore, it is not safe for our lives to release the accused person from jail. Might be they have changed their mind because of the motherly love and all at this stage. But then this is on record. But the fact remains is that he used to try to kill his parents when drunk. But he knew that they knew that he had the intention. He had the intention for a long time. Now he put it into action. If I may take Your Lordship kind attention to page number 11 again, Your Lordship. Page number 11, this is the cross-examination of PW number 1, who is the complainant. Sorry, page number 10, PW number 1, second paragraph from the last. Second paragraph from the last, the third line, near the signature.
I do not remember.
I do not remember the exact year. It was around 2002 to 2003. The accused tried to strangle PW number 2 at the residence of Bongkon Brigade and almost succeeded. The accused often threatened PW number 2 and 3 previously before this incident countless times. PW number 2 is the father. And in page number 11, paragraph number 5.
Page 11, paragraph 5. Yes.
5 and 6. I know that prior to the alleged incident, the accused used to assault my parents under the influence of liquor. 6. It is not a fact that the accused never assaulted my parents before this incident. So all the prosecution witness have proved beyond reasonable doubt that the intention is clear, that he tried to kill his parents several times. Now he almost succeeded before also, but now presently he succeeded. But then luckily the cause, even though he intended, the intention is very clear. The injury that was sustained by the victim was not that of a grievous one. Now, when looking into the authority that is laid down by the apex court, we know that it is a settled proposition of law that even if the injury is small, then the intention, the weapon used, and the reason for the grievous cause that is the grievous hurt that is caused should be taken into account, not the fatality. And Your Lordship, my last contention, he's a habitual drinker. I have already taken Your Lordship kind attention to the cross-examination wherein the mother said that he have feared for their life and if he is released in person. That is my point. And PW number 2. He page number 14. Page number 14, 866. Serial number 1. Yes, page number 15. This is the PW number 1 cross-examination. Serial number 1. It is the fact that the accused person is a habitual drinker. He on various occasions would come home drunk. And Your Lordship, being drunk, he have taken the plea of being drunk in 313, though he do not adduce any defense before the learned trial court. But then I am still going to make a submission on that regard, just in case. Because being drunk cannot be an excuse. In this regard, I'm going to cite the authority of Nanhe versus State of UP, 2023, SCC, online, SC 1491, para 25.
2023.
2023, SCC, online, SC 1491. So to sum up my argument, para 25, Your Lordship. To sum up my argument, Your Lordship, it is fortunate, and I am happy that the victim do not sustain any fatal injury. But in this case, the intention, the weapon used, and the action that is undertaken have only pointed towards the 307, that is attempt to murder, because he, just before the incident, he said that I'm going to kill you all. And 326, that is voluntarily causing grievous hurt. He knew that he can cause grievous hurt. And 324, that is voluntarily causing hurt. So the conviction is, the ingredients is all there, is complete. So my humble prayer is that to uphold
this 2023 SCC online is on what point?
On habitual drinker, and the intoxication cannot be the ground for excuse. Just that.
My Lord,
Yes.
if I may submit a small
Yes,
submission
any reply?
regarding the property, my Lord, the weapon, my Lord. It was stated as 1.5 feet long, but my Lord, the diameter has never been proved, my Lord. Diameter on the thickness of the. And my Lord, regarding the prior incidents where the victim has claimed that they had been previously assaulted, my Lord. If I may take Your Lordship straight to the page 12 of the evidence of the PW number 2, my Lord. The last para. The accused person had previously tried to kill me by strangulation. I survived only because my wife and my daughter had intervened, my Lord. In here, he stated that his daughter was there at a prior incident, my Lord, but he was never listed as a prosecution witness to prove that there was a prior incident, my Lord. There was no proof of the prior incidents as mentioned by the PW number 2 and PW number 3, my Lord. And my Lord, regarding the intention, if I may submit one judgment, which is 1998 Supreme Court cases 984, 1998 ACC online SC 241. That is Hari Singh and Sukhbir Singh and others, my Lord. Para 7, my Lord. If I may read.
1 minute. para 7.
Yes.
Yes.
On the first question as to acquittal of the accused under Section 307, 149 IPC, are some significant aspects may be borne in mind. Under Section 307 IPC, what the court has to see is whether the act, irrespective of its result, was done with the intention or knowledge and under some circumstances mentioned in that section. The intention or knowledge of the accused must be such as is necessary to constitute murder. With this ingredient being established, there can be no offense to attempt to murder. Under Section 307, the intention precedes the act attributes to the accused. Therefore, intention is to be gathered from all circumstances and not merely from the consequence that ensue. The nature of the weapon use, manner in which it is used, motive for the crime, severity of the blow, the part of the body where the injury is inflicted are some of the factors that may be taken into consideration to determine the intention. In these cases, two parties in the course of fight inflicted on each other injuries both serious and minor. The accused, though armed with balam, never used the sharp edge of it. They use only the blunt side of it despite their being attacked by the other side. They suffer injuries, but they were not provoked or tempted to use the cutting edge of the weapon. It is a very significant. It seems to us that they had no intention to commit murder. They had no motive either. The fight, as the High Court has observed, might have been sudden flare-up, where the fight is extended owing and to a sudden quarrel. The conviction under Section 307 is generally not called for. We therefore no reason to disturb the acquittal of the accused under Section 307. Herein, my lord, as per the evidence of the PW number 2 and 3, my lord, the victim, my lord, on their cross-examination, they have admitted that on para para 8, my lord, it is a fact that the alleged incident started and to which the accused confronted PW number 3 and myself due to sudden provocation, where the PW number 2 has and 3 has admitted that it was due to their sudden provocation, my lord. And my lord, regarding that, the accused has only hit it once, my lord. There were no repeated blows. And at the time of the incidents, nobody was there, my lord. If he had an intention, my lord, he had a chance to commit a murder as constituted in 300 of the APC, my lord. There were no repeated blows, my lord, and there were no preparation. The incidents happened due to the sudden quarrel between the PW number 3 and the accused himself, my lord. And my lord, one judgment where
This is by prosecution.
yes, where there is no, where the Supreme Court has
1 minute, okay.
altered the conviction.
PP, this 2023 SCC online.
Nanhe versus State of UP.
Yes, Nanhe. This one is para the relevant
25, Your Lordship.
25.
Yes.
Yes.
My lord, one more citation. This is regarding repeated blows, my lord. 2023 SCC online SC 158. Para number 10, my lord. Having considering the facts and circumstances of the case and submission of learned counsel for the para 10, my lord.
10.
This court is convinced that impugned judgment of the High Court requires to be interfered with. Immediately, there is no allegations of repeated or severe blows have been inflicted. Even the injuries on PW number 1 and PW number 2 have been found to be simple in nature, which is an additional point in the appellant's favor. My lord, in here, the conviction under 307 has of 307 of the RPC has been altered to 324 and 323, my lord. wherein there is no repeated blows and inflicting only simple injury, my lord. So, my lord, my humble submission is that the conviction under 307 and 326 may be set aside, and maybe conviction may be altered to 324, and the conviction may be altered to 324 only, my lord. And
Heard learned counsel for the appellant, Mr. Such and Such, also heard Ms. Mary L. County Learned Public Prosecutor for the state of Mizoram. So, Judge, hearing is concluded. Order reserved.
Deeply obliged.